So hey, Attorney Peter Olson here, Chicago Family Law Group. Tell me if anybody has any audio difficulty. I do these webinars just infrequently enough that I don't feel totally confident in my expertise in using, GoToMeeting or whatever software we have behind this. So that's just my little quick spiel. And I'll just say up front, let's see, I mean, there should be a chat box and stuff, where you can throw some questions in here. I think expecting a couple more people on the call, but, whatever. It's, I've got about, 12:01 Chicago time. So I'm going to get going. And, yeah, just fire away with questions. The great thing about the webinars and stuff is presented at a an in-person seminar, I think on September 30th, and you have a little less control over the questions and stuff, and sometimes the audience when you're doing a live presentation. But here, right, you can send your chat box questions, and if it's I can answer whenever I want to. So let's get going. And I guess chat me if you have any just sort of technical things. I may or may not be able to help you. Like I said, I've probably done about 10 of these webinars at this point. We try to do them quarterly, but I'm not an expert on GoToMeeting software. So I'm Peter Olson, Chicago Family Law Group. We're a 5-person, 3-attorney divorce and child custody law firm up in Chicago, and all we do is help people in their child custody and divorce cases. That's really 95% of what we do, right? And essentially I'm a real big fan of, you need to be specialized, you need to be focused on what you're doing, especially in a big market like Chicago. And more importantly, really just the complexity, all parts of law these days. I mean, they're so complex and just constantly changing that, we only play in 2 boxes. People going through divorces where, the child-related issues are exactly the same, whether you're married or unmarried, 90% exactly the same. There are a few little things that are different, but so people going through divorces with kids, and then obviously in a divorce context, sometimes you can have property and alimony and other issues. And then the other type of case we deal with are what we would call a parentage case, or I think what a lot of people would call a child custody case. In other words, people who are unmarried and have children together. So that's really all we do. That's all me and my staff do. And so I think I know we're pretty good at it, and also really have a nice little customer service team too. So I think if you have some needs or in this space personally, we always do a free initial consultation. We're at familylawchicago.com is the website. I think our scheduling button actually is a little broken right now. Our web person's on it. Our main phone number is the 312-893-5888. We'll always do a free initial consultation. If you want to do an in-person, that's always preferred, or, if you're not local, our main office is downtown at 20 North Clark in Chicago. Alternatively, we have a couple suburban spaces. If you're out in the north or northwest suburbs, we have a place in Park Ridge we use, in Schaumburg and Oak Brooks. So, yeah, we really want to. The free initial consultation is a great way to kind of get yourself headed in the right direction, even if it isn't something that's going to be in court for a long time. So, but today we're really talking about custody, and I'm going to actually, I think, shut down this webcam, and I'll keep the screen share on. Just wanted to, make sure you knew who you were talking to or something here. But here's the screen share, just our slides: how to win custody of your kids in Illinois or get the parenting time you want. 9 common questions answered. at a real top level, Illinois family law, it's amazing. I was just thinking about this, just getting ready for the presentation today. In Illinois, we're always talking about how, the state's gridlocked and we haven't passed a budget or whatever, and we owe billions of dollars in past due bills. What I get a kick out of is in the narrow area of family law, divorce and custody cases, we've had more new and changed, modified legal stuff in the family law space in the last 2 years than at any other time. I just celebrated my 14th year as being a licensed attorney in Illinois, basically November '02 to present, November of 16, now December. There's never been as dramatic of changes in the whole practice field since from, let's say, '02 to 15 versus now 15, 16, and another big change happening next year. A huge change happened in 2015 with regards to alimony or maintenance payments. A huge change happened this past year in regards to parenting time and custody, and a huge change is coming next year, just to tee something up, with regards to how child support is handled. So, if you have stuff in these areas that maybe was in court in the past and you haven't changed, or this kind of thing, might be a time to take a look at it, because a lot of the stuff has changed. So let's get going on our slides here. So how to win custody of your kids in Illinois. Question 1, just sort of generically, what is custody? What is visitation? Because here's the thing, right? And some of these slides need to be updated a little bit too. That's actually the big change that happened last year. And I don't think this is actually one of the huge changes. It's one of the huge changes, just I think it's more of a semantics change than a substantive change. But we don't actually have custody and visitation any longer in Illinois. Even though I call the presentation How to Win Custody of Your Kids in Illinois, we have allocation of significant decision-making authority, and we have parenting time. Those are the two things that have actually replaced custody and visitation. Now, like I said, I think of they're mostly semantic changes, because custody always meant who was responsible for major life decisions of a child, whereas visitation was the timepiece. But there were a lot of misconceptions, I think, about those two areas, but that's really what we're talking about here. So, those are our two big pieces and sort of top-level stuff for what we're dealing with today. Who's responsible for decision-making with regard to children? What are your big areas? Education, healthcare, religious training. Right in the sole decision-making piece there that we're looking at here, right? One parent is responsible and has ultimate sort of power and, I would say veto power in terms of, where, little Johnny's going to school, what doctors and dentists they're seeing, that sort of thing. Now, one misperception, right? Even in one parent is solely responsible for the decisions with regards to their children. Even in that place, the other parent absolutely has access to records, has access to information, and should and can be involved with that stuff, right? In other words, I may not have the right to decide where my son is attending school or what pediatrician he's seen. However, I absolutely have the ability to get school records. I absolutely should be on the school's mailing list. I absolutely can and should be part of conferences. I absolutely can and should be part of medical appointments and stuff like that. I think that's one big misperception. Even whatever, if I, and I don't, but if I had an ex-wife or a mother of children who I wasn't married to, and that person was the solely responsible for significant decisions, that person absolutely gets to make those decisions, but I absolutely am entitled to be involved. I'm absolutely entitled to information. Right, the old in that second bullet point there, sort of shared decision making is really, right, that idea of really what we used to call joint custody or joint decision making. Parties are supposed to make decisions together, or at least get input from each other before they're deciding things like school, medical care, and things like that. You know, sometimes this is worth fighting for, sometimes it's not. I think one of the most frequent causes of what I think of as unnecessary litigation historically has been the idea of, and this is playing to a stereotype, but you see a lot, is it's males, fathers pushing for joint custody or pushing for shared decision making with the thought that it somehow affects his or her requirement to pay child support. That's not the case. It's never been the case. But you hear it, let's just say, on the street all the time. Oh, if I get joint custody, I don't have to pay child support. It's never been true, and it's still not true. So a lot of times it's something where it's people are fighting about something, trying to win something that basically gets them no benefit. So there are a lot of ways to handle, you know, is sole decision making, is shared decision making the right way to go, you know. My experience is a lot of times there aren't that many big decisions that people disagree on. You know, how often do people really disagree on schooling? You know, in my experience, kids are often going to the school where, you know, one of the parents lives in that school district, and, you know, they've usually been seeing a medical provider, you know, their entire life. And how often does that change? And then lastly, parenting time, right, what we used to call visitation. This real world is, I think, oftentimes worth fighting for a lot more than actually the decision-making piece. Because like I said, in my experience, a lot of people really don't disagree about a lot of the major life decisions, and really the thing worth fighting for is making sure you're getting that time that you're entitled to. Because that's one thing I've seen in the last probably 10 years or so, is just, and the public policy of the law in Illinois states specifically that the custody and, you know, basically the Illinois Parentage Act and the Illinois Marriage and Dissolution of Marriage Act specifically speak to the idea of encouraging the maximum involvement of both parents. And that's what I've seen a lot more in the last 10 years. I'm thinking early in my career, first 2 to 3 years of those 14 years that I've been doing that, there's, you know, yeah, you clearly had somebody who was like the 80 or 90% parent, and then somebody who was the 10 or 15% parent. Not the case anymore. I'm seeing much more, I wouldn't say 50-50 is the norm, though that does come up on occasion, but I would say that 30 to 40% and 60 to 70% is much more the norm than sort of the old alternate weekend father who, you know, got 2 or 3 days out of 14. Now I'm seeing much more like, you know, 5 days out of 14 or something like that. So that's what we're talking about here at a real top level. Decision making and time. Second question, do I have a right, basically, do I have the right to get custody or time with the child? And this, right, in some cases this is obvious, some cases it's not, right? Are you the natural mother? Did you give birth to the child? Yes, you're right. You're entitled to potentially get awarded the ability to make significant decisions about a child. Really the only bullet point there, right, where mom's not going to kind of be in that space would be number, you know, it's just the no, right? If right, child had been given up for adoption, or sort of the artificial insemination, some of those, or a surrogate parent, those kind of situations. The father is the more sort of the common one that we're seeing a lot. So are you the natural father of the child? Yes. And then here's where it gets just a little strange, is kind of in the married versus unmarried context, right? If if a father is married to the woman who gave birth, legally he is the presumed legal father of that child, and therefore, yeah, he absolutely can bring a case for custody and parenting time and such things. However, in the unmarried situation, that's oftentimes the situation where something has to be done before father has the right to ask for parenting time or has the right to ask for significant decision-making responsibilities, aka custody. I literally have a case in court tomorrow where we're potentially trying to get a gentleman some temporary parenting time. However, as we're talking right now, as I'm talking right now, he hasn't established himself legally as the father. So he and the alleged mother were, well, I guess she's not the alleged mother. She's the mother. He's the alleged father. Were ordered to do DNA testing, and I think actually in court tomorrow we're expecting to get those results back. So, assuming he's found to be the biological father, then, we're going to have a court order entered. This guy is now declared the legal father, and then, okay, now he's the legal father. He can ask for absolutely everything that the mom can ask for. That's one. So that's just the piece there. Is if you aren't married, you need to get established as the legal father, or you've got nothing. And then, but once you're in play there, once you are established, both parents have absolutely the same legal rights. There's no gender specificity or anything, right? You'll see some law firms even like market themselves as women's lawyers or mother's lawyers or father's rights lawyers. Those are, I think, sort of actually decent and sometimes effective marketing strategies as a law firm, but legally, father can ask for everything and anything, and so can mom. There is no such thing legally as father's rights or mother's rights. There's parents' rights. So mother, father, and then this last bullet point here is a little bit rare, but it comes up on occasion, just depending on what you're talking about. And this would be sort of non-parents having the right to have custody, decision-making, or visitation, right? And that's really the crux. That's really the top question: is do you have possession of the children? Because generally, parents' rights are above, and legally they are above non-parents' rights. However, there are times when a non-parent, grandparents will deal with quite a bit, or other situations. But the first crux of it is do you have possession of the child? And in that situation, you do have the right to actually do some of this stuff in terms of parenting time, financial support, custody, but it really is that possession piece. And then I guess I have this last little point here, active duty military situation. There is an interesting thing that we'll use once in a while where it's substitute parent. It's basically, I'm forgetting what the law actually calls it. It used to be called substitute visitation. It's probably called substitute parenting time now, but it's where mother or father is on active duty military, and in that situation, that parent has the right to sort of assign another relative or close friend of theirs as their substitute person. And now, my mom or my aunt who's still here in Chicago while I'm in Iraq or something, has the right to do and experience my parenting time, while I'm away active duty military. So that's definitely something to keep in mind. I can think of 1 to 2 cases right now where we're doing that. So, but yeah, I guess the summary just for this slide is just sort of think through, this is sort of top level stuff. Generally speaking, mothers, natural mother's almost always going to have the right to custody and parenting time. Natural father has to establish themselves first, or they don't really have much, and that's critical. Because a lot of people sometimes, they've been doing parenting time. They've been establishing, real world, a relationship with their son or daughter, or the person who they think is their son or daughter, but then they don't do it legally, and they're leaving themselves really, really vulnerable. That's a huge one, is fathers who haven't established themselves, and then something happens, and next thing you know, the kids are gone, and there's not much you can do about it really quickly because you haven't established yourself as the legal father. And then I guess just lastly, right, this last one, some unique situations. If you have possession of children who aren't yours, it might be a good idea to get a guardianship or get custody of those kids for, sometimes maybe for public benefits reasons, sometimes to get financial support from the natural parents, sometimes to, allow yourself to help those kids with regards to getting them in school, getting them to a doctor, this kind of thing. How does a father establish a legal parent-child relationship? Touched on this quickly in the last slide, just sort of the idea, a father has to establish himself as a legal parent. Right, paternity definition, the legal relationship between a father and a child, and here are the 3 ways to do it. Voluntary acknowledgement of paternity is an administrative form that mom and dad sign and have witnessed. That is just, it legally makes somebody a parent, a legal father. That's a one way. Secondly is an administrative paternity order. That's basically through sort of like what we would call like a state child support case. That happens as well. And then lastly would be a court order of parentage. That's literally what I expect to be doing in a case of ours tomorrow, this one I referenced, where the parties, a couple months ago, were ordered to have DNA testing done. Then we're going to get the lab results back tomorrow, and then assuming our client, I think he believes that he's the father, assuming it comes back that he is in fact the father, we'll enter a court order of parentage. So any of those 3 things is fine. I mean, the warning on the first one, the voluntary acknowledgement of paternity, is, to be frank, is, father, you need to be sure. I would recommend that you want to be sure that you actually are the father, because that voluntary acknowledgement of paternity form is just as legally binding as a court order of parentage is. So if there's question about it, you might as well wait a couple months and get those DNA test results back, because the alternative oftentimes is, and this happens more than you would think, as somebody who's in this field, I would bet that 20% of the cases, somewhere like that, a big number, 20 might be a little high, 15 of cases in, this part of the court system, child custody, parentage cases, there's a big percentage of those cases where the guys who are the legal fathers, I bet, are not the biological fathers. And how did that happen? They signed a voluntary acknowledgement of paternity without actually being sure that they were the father, and it's really, really difficult, oftentimes impossible, to get out of that voluntary acknowledgement of paternity. So that's a strong word of the wise. And why establish yourself as a legal father? Let's get these all out here. I should have them all coming out at the same time. Right, some of these I think are probably self-explanatory, right, to be on the birth certificate. Just had a case not long ago where we changed custody to a guy, but he wasn't on the birth certificate yet. And, we were able to clean it up, but he needed the birth certificate to get these kids in school down in Georgia, I think is where he went. To protect your rights, right? You can't do any of those pieces, right? Parenting time, visitation, financial support from the mom. None of that stuff happens until you're actually found to be the legal father. Protect your child's right to a parent-child relationship, right? Information access, financial benefits, all those sorts of things. That last one's a big one. This happens more than you think. We call them in our firm the grab and run cases, and they happen all the time. We probably get 2 calls of these every month. And this goes both ways. I'm just saying, and the question I'm posing here, right, why do I need to establish myself as a legal father? So I'm looking at it from the father's perspective, but you get it from the mother's perspective too. But the mother can take the child wherever she wants in the world. Where are we? 3-4 years ago, just remember this case clear as day. We had a gentleman with, did he have twins? It's been a few years, but you know, they weren't newborns by any means. You know, it's something he hadn't acted on. He hadn't established himself as a legal father. He was doing all the parenting. He was doing 99% of the parenting time. You know, he was the main parent, just by far, but nothing had been established. And then I believe, as we're sitting here in December, right, I think the mom showed up literally at the school, something like the last Friday before spring break, grabbed the kids and ran to Mississippi with them and sort of disappeared. Fortunately for our client, we got a great result for this guy. Fortunately for our client, he knew enough about the mother, and sort of, I think she, maybe her parents, or she had some extended family down in Mississippi, so he knew where she was. So then we were able to basically do what we call an order of protection, where we got temporary possession of the kids for this guy. And then, but you know, he's still, right, we had to go to court to do that. Then he had to go down to Mississippi, and I'm forgetting, you know, some sheriff's department down in Mississippi, and get the kids back. So I don't want to underestimate that risk at all. That's a huge, huge problem. And understand, right, that result wasn't a bad result. He got his kids back, I'm thinking, it's probably less than a week or something like that. However, the same exact situation, if he doesn't know where the mom is, if he doesn't know that, hey, she's from Mississippi originally, she's got ties down there, I know where she is. If he doesn't know that information, kids could be gone for good. You know, right? So this, right, primary parent, primary provider for 7 to 10 years of a kid's, of these, I believe it was 2 kids' lives, is just totally out of the picture. You know, I mean, think about, you know, how vulnerable the kids are, and think of yourself as the father or the mother who now, you know, this huge part of your life, critical part, you know, what you're here on earth to do is provide for these children. You're just, you know, you have the carpet pulled out from under you. So critical issue. Question 5, where are we? How is custody determined? Best interests of the child. This is a little bit of overly legalese, so I think I changed my, I think I added something on this. Let me grab this quick. I wrote a blog post on this recently that I think is actually better than a lot of this stuff that we have here. I mean, this is sort of, this is the legalese. This is, you know, this is the legal standard for sure. Let me see if I can't grab this web page quickly. Our blog. Let me see if it pops up quick here. I know who uses Internet Edge Explorer here. Give me 2 seconds. So here's a blog post I wrote recently that I think really, right, How to Win Custody of Your Kids, shortened version. This is really 5 critical bullet points that really, I would say, gets it a little easier to understand versus just kind of looking at that best interest standard, which is what the law is. But here's, right, think about these few things, and I think the top ones are actually the most critical. Because one of the factors is the willingness and ability of each parent to facilitate the relationship with the other kids. This is critical and the hardest one to thread, right? Because if you're going through sort of this court process where you're, right, in a sense, you're fighting with the other parent about who should be sort of the primary parent, who should have primary responsibility for certain things. So I guess what's the point here? The point is, right, people get a little bit antagonistic and not, right, not on the best of terms. That being said, you have to encourage the relationship with the other parent. That's absolutely issue number one that a judge is going to look at, right? If I'm a judge, I'm thinking, hey, this case is in court right now, and this woman or man are under my nose, or, you know, under my thumb, so to speak. And if he or she right now, under the glare of court appearances every couple months, is doing everything they can to frustrate the other parent's parenting time, I'm not going to give custody to this person, because think about it. A few years from now, this case is out of court. You know what I think is going to happen? I think that he or she is going to just totally stonewall the other parent. So this is absolutely the most important thing, is facilitating the other parents' parenting relationship with the kids. Be involved in your child's life. And that's usually just kind of that history. You need to know the teachers, doctors, coaches who are working with your kids. You need to attend the conferences and appointments and games. You need to have that track record, right? I mean, unless you're talking about a newborn kid, a lot of times cases getting into court when a kid, right, is 5, 10 years old, and now it's like, oh, yeah, I want to be the primary, I want to have this, I want to be solely responsible for significant decisions of my child, but yet over the last 3 to 5 years, you know, I haven't been to a school conference, I haven't been to a medical appointment, but hey, judge, I want to do that now. You know, track record's critical. Quite honestly, if you don't have the track record, it's probably not worth your time to even try to get custody, because you're not going to get custody. You need to have that history of involvement, or quite honestly, usually I'd be dissuading somebody from you know, really fighting about decision-making power. Have a support system. I think that's important. And I guess just back to this one, right? A lot of times, if I'm actually in a trial setting, you know, I'm going to be asking that other parent, hey, talk to me about you know, little you know, Margaret's third grade teacher, you know, and second grade teacher. What were their names, and you know, how involved were you with them? And yeah, what's the name of the doctor that little Margaret's been seeing? Right? You'd be surprised at how often, oh yeah, you know, I want to have significant decision-making responsibility for my kids, and oh, but you know, I don't know who their elementary teachers have been for the last 5 years. So those are big ones. Support system, I think, is critical. A lot of times, if I'm having a custody trial, you know, I'm talking about here 3 types of witnesses that I would typically use, right? The party themselves, something like teachers and coaches, but then also extended family, close friends. Oftentimes that would be a critical person in a case. I'm thinking of oftentimes a parent's mother or a grandmother, a lot of times a real close friend sometimes who maybe you have children the same age, or this kind of thing. I think that support system's key real world, and if we're having a hearing or a trial, it's critical in terms of like presenting our case. And then just, I think those 3 are absolutely critical. Last couple bullet points here. Education matters a lot, and I put in parentheses, particularly in minority or lower income households. I think that's true. I think I wrote this blog post right after we'd actually flipped custody in favor of a client of ours, a guy, and absolutely it was in the forefront of my mind, an African-American guy, and what won the case, I mean, you never know, I wasn't the judge, right, I was this guy's lawyer, was that when it was I think an 8th grade or 7th grade daughter when she was with the mom, she wasn't going to school. Like I remember, like one of our key pieces of evidence was it was like the kid missed, was it 60 days or something in the last school year? Just crazy, crazy stuff. But that's critical, right? Judges are lawyers. I'm a lawyer, and the bottom line is, these people have a lot of education, and I think just there is a bias towards a wanting, that education piece to be okay, particularly in lower income families, because I think the thinking is, that's where the education has to be coming from almost more so. And then parental maturity, sort of discipline stuff. I just remember a case here where one parent was really immature. That's sort of where that idea came from, and it really showed. I remember we flipped custody, or actually we won custody originally for a guy in a case where the mom was really immature. She was still living with her parents. She didn't really have a job, and you could also just see she wasn't really leading her son as a parent. So those 5 things are really the big focus there in terms of custody. But that first one's the hardest, but you have to do it. And I can just think of a number of our cases, just even currently, where you have clients who they want to kind of, not facilitate. They want to bicker and kind of cut out the other parent, and it's like they're not doing themselves any favors in terms of actually getting what they want in the end, if they actually do want to win custody, or if they do want to be awarded, sort of the majority parenting time. Oh, no, I don't know how to go back. If I don't, here, question 6 was, if I don't get custody, do I have a right to parenting time with my child? So the answer is absolutely yes, right? And the slide was yes, a parent not granted custody is entitled to reasonable visitation rights unless the court finds, after a hearing, that visitation or parenting time would seriously endanger. That's the standard. That's serious endangerment standard. Right, the 95% of cases, and this is quite honestly, unless you have a situation where, and it really is the severe stuff, the severe problems on the part of a parent would lead to limited or restricted parenting time. Things like, right, I mean, you have a child molester, a sex offender, or serious felony stuff. Drunk driving sometimes can be a big issue, especially if somebody's, right, responsible for transportation during a parenting time. Those are things where somebody's parenting time would be restricted. Probably the most frequent thing that I see in terms of somebody actually not having full parenting time would just be more where somebody's just been out of their kid's life for a few years. Just met with a new prospective client last week, and this guy, and a lot of times it may have been caused by the other parent, but this guy hasn't seen his 2 kids now in a couple years, and they're older. I think they're 10 and 13 from my recollection. And I was just telling him, look, you're absolutely entitled to normal, reasonable parenting time like the law provides. And I told him, you'll absolutely get there. Hire us, we'll get you going. But that being said, there'll probably be a little bit of a ramp up. It'll probably be 3 to 6 months of him having to, maybe do some therapeutic parenting time where, he needs to kind of sit down with them and maybe a counselor to sort of help them sort through some of their baggage. Or maybe he needs to start out with some, just going to McDonald's on Saturdays or something. And then as long as things go well, he'll absolutely get ramped up. But that's probably the most common situation that I see where somebody doesn't have full on, 30 or 40% time with their kids. Would just be, there's been some period where no parenting time happens, and now there's maybe just a little bit of a discomfort, or just a judge wanting to be sure that everybody's on the same page, and mostly just that children are comfortable with this woman or man who they haven't seen in 10 years or something. Hopefully not 10 years, but Is there a standard parenting time schedule? I would say in a couple of varieties, the answer, really is no. I would say they're fairly common setups when you have, right, everybody's local, or when you have an out-of-state situation, right? When you have parents, one parent local, one parent in Arizona, for example, right? And I think I've quoted this before, right? This is absolutely what the law talks about. The maximum involvement of both parents is to be encouraged. Now, right, back in the old days, you used to have the alternate weekends and one weeknight. Like, I think that's the minimum right now. I mean, the only times I'm really seeing that, and I mean, this happens, really would just be if one of the parents' schedule dictates that. I could just think of some of our clients who are, just really busy, or maybe sort of like business executive kind of people, where it's like their time is really full, and it's like maybe that alternate weekend schedule is all that's realistic. But if both parents, if dad and mom, in fact, their schedules allow it and stuff, I would say the normal schedule right now in terms of regular parenting time would be much more something like, at a minimum, getting the kids from school on Friday, bringing them back on Monday, or getting the kids from school on Thursday even, and then bringing them back on Monday. Excuse me, to school on Monday. Maybe doing that on alternate weekends, and then probably on the week when that parent doesn't have a weekend, probably getting in another overnight, maybe Tuesday to Wednesday morning, Wednesday to Thursday morning. So I'm seeing much more like that now. Not alternate, maybe alternate weekends, but much more like expanded alternate weekends, and then another overnight somewhere in there, where you're getting, I would say, more like four overnights out of 14 days, 4 or 5, where you're at more of like one parent's sort of like 1/3, 2/3, or 40%, 60%. We do have plenty of cases where there's an equal parenting schedule. I guess I do say their schedule is not suitable for most families. When we do see that, and when I do actually recommend it and would find it suitable, really depends on just how close the parents are to each other, and I mean geographically. When you have parents in the same school district or living in the same town, I mean, you say same school district, they could be, right, both in the city of Chicago, it's a huge city, but you have two parents both living in Park Ridge or something, which I think I had that case fairly recently, and that was one of the more recent 50-50 parenting time cases we had. You're in a smallish suburb, everybody lives in that suburb, and so then that works, right? I mean, they're both close to the schools, they're close to the kids' activities, so that can work. So are the parents really close to each other? I think the other piece of it also would be, a lot of times before a child is of school age, prior to age 5, you have a lot more flexibility in terms of time. So that's another piece to think about, right? We're having a case with a newborn, right? You have 5 years there where there's a lot more flexibility, right? In terms of, right, they're not tied to a school schedule. Maybe you are doing some daycare, preschool. I understand that, but you do definitely have a lot more flexibility preschool as well. So 50-50 works, but I would say in narrow circumstances. Out-of-state schedules are very common these days. I'd say probably 20% of our cases right now are out of state, not necessarily in Indiana. Probably, yeah, the most recent out-of-state one I just finished up was actually a woman where we got her the legal right to relocate, actually, a daughter, a 4 or 5 year old daughter, to Arizona permanently. But that father still has out-of-state parenting rights. And so what's going to be out of state? Larger chunks of time that occur less frequently, right? I'm an out-of-state parent. I'm going to get a lot of summer, and I'm going to get some of the big break periods. Maybe I'm going to get 8 weeks over the summer. I'm going to get spring break every year. Probably going to get at least half a winter break. I'm going to get the week of Thanksgiving, and then depending on how much, probably the only limit really just becomes how much, frankly, travel resources. How easy or hard is it for you to be funding flights and stuff for little Johnny to come out by you, or conversely, a lot of times you could be coming here to see the kids so out of state has a lot of ways, but that's the general picture, is less frequent but larger chunks. If you really add up the time on some of the out of state cases, a lot of times that parent gets as much time as the person who's getting 3 or 4 days every 2 weeks. In total, it's just less frequently. And I just include a little bit of a definition there on supervised visitation and what that looks like. Right? What's supervised in a nutshell? Maybe some extended family member is going to be with that parent while they're parenting. Sometimes those are just going to be maybe parenting's happening in a public place, like at a restaurant or something, I think, where judges just think, nothing's going to happen as long as they're in this setting. Or alternatively, there are actually sort of centers and such that we use, sort of, they're sort of like the equivalent of going to the Y, where that actually do visitation supervision. The last alternative on that, there is a place actually that will ride around with one of the parents as well, sort of like I'm a supervisor and I'm going to do whatever mom or dad wants to do during his or her parenting time. How do we change custody? Down to the last, I think, 3 slides. I've got about, 12, 47, 48 here in Chicago. Changing custody. So changing custody or significant decision making, changing visitation or parenting time happens a lot. So let's go through these bullets. Changing visitation and parenting time is common and easily done, right? All of a sudden my work schedule changes, where I live changes. That's an easy change, and I mean, right, no guarantees, but visitation changes and just schedule changes are not difficult. If you have a decent relationship with the other parent, I mean, honestly, that should be handled through a phone call. If you don't have a decent relationship with the other parent, that's something we help people out with all the time. Petition to modify parenting time, petition to modify visitation. As long as it's sort of right, reasonable things have happened that require the change, that's going to get done pretty much guaranteed. You still need to get a judge to order stuff, but that's going to happen. Now, custody or changes to significant decision-making responsibility, or really, I guess what I would say even more broadly, kind of changing one parent being the majority parent to the other person being the majority parent and the major life decision-making, those are hard cases and big changes. I'm not saying they can't be done, because actually a few of these stories that I've shared throughout this presentation are exactly those types of cases, but they're difficult, and I think people think sometimes that it's just like, oh, some little thing has changed since I was divorced 4 years ago, and now I want custody. That's rarely going to be enough. I'm thinking about 2 or 3 of the custody, because right on the judge's perspective or on that side of the fence, think think about how drastic of a change this is when you're talking about changing sort of who's the 90, 80% parent, where that kid's going to school, where that kid's living. That's a huge change, and it's not going to be done simply or easily without significant, basically concerns, I think, from the judge's chair. 2 or 3 just off the top of my head, and just to emphasize how serious stuff needs to be going on. I shared one story already. That was real. We just flipped custody in August to a guy where basically, right, it was more than this, but I would say the number one issue was the kid wasn't going to school when she was with mom. Judge changed custody to dad. Another one just off the top of my head is a guy we flipped custody to, where basically what was happening there, and this is sort of a warning to people who don't allow the other parent to have their parenting time. We had a woman who just totally denied this guy's parenting time. He was a good guy. He is a good guy. Totally a normal kind of executive professional level person. But for whatever reason, the mom would just deny him his parenting time just repeatedly. And just egregious stuff. Just make up fake sicknesses, and she'd go to the emergency room like on Friday nights when it was his time for visitation. Just ridiculous stuff. That kind of thing. We flipped custody to this guy because we showed the judge the history of, like, if this mother kept this kid, he's never going to have a relationship with his father, and the father, that was something that the court wanted and should be encouraged. And I guess the last one, just thinking out loud, would be, real serious stuff. I can think of a case not long ago where we flipped custody to a mother where the father had remarried, and all of a sudden he's got this new wife who's really tormenting the kids, and then the new wife had some other kids too, and some real serious stuff was happening with some adolescent females, I think in this case, the kids, like cutting themselves, real serious kind of like suicidal sort of stuff. So visitation, I guess the bullet points here, visitation parenting time is pretty easy and common to change. Custody change is really one of the bigger, more difficult changes, and that's not to dissuade somebody. If you have serious stuff going on, like some of those examples I talked about, you should try to do it, and we can help you do it. But it's not just like, oh, little Johnny got a C in math. We need to change where he's living. Here, 2 more slides. Is formal court-ordered custody visitation even necessary? I think, I'm not even sure why I have this slide on here, right? No, if you're married and have an intact family, obviously not. Unmarried parents, I would say it would be the situation where you really should have it, because just because those are the cases where I see a lot of those situations just being a free-for-all if there's not sort of a court order in place. And married separate, and those would be sort of like what I would call a pre-divorce case or something, just while a case is going on, while somebody's going through a divorce, typically we would have a temporary parenting schedule or things like that. And then I just have one more slide here, so chat out any questions if you have any. Or certainly, go to our website or give us a buzz if you have really specific personal questions that you'd rather, sort of have answered in a one-on-one context. Oh, goodness. What is the court process? I need to clean up these slides a little bit. This is ridiculous. But here's sort of the picture. And I actually have a pretty good flow chart. I think I might pull up in 2 seconds here as well. But one more. Here's what I'm going to just, I wanted to give a little bit of just a feeling for timing and just sort of what it looks like. And actually, let me pull up this flow chart. It's more easy to understand, I think, than this slide is. But right, in terms of timing, here, let me grab this quick. Just closing out here. Let's see, child-related flow chart. Your last slide, and we'll sort of wrap this up here. But this is just sort of a real broad sort of global level, right? Plenty of cases are actually over on this track here, proceeding as an uncontested matter, you know, getting agreed order entered in literally maybe 1 or 2 court dates. It's just in court today on a case where it's like everybody's chill. It's just like they had a divorce judgment that said, our client, the father in this case, was entitled to reasonable visitation. And then what's been happening is just because there's no specificity, he's getting time with his kids, but sort of like his former wife gets upset about something, she pulls back. So that being said, she is an attorney who's sort of a, let's just say it's somebody I know and have a decent working relationship with. So we're going to be able to work something out pretty easily. Now, so right, 1 court date, 1 to 3 months, I'm just throwing that out there. Proceeding as a contested matter, and then this is, right, there are all sorts of different ways this can go in, but very typically, right, this would be, you know, you get a case in court, whether it's a divorce or a parentage custody case, right, a lot of the first things we would do would be getting a temporary parenting time set up. One of the first things you're required to do by local court rule, whether in Cook County or any of the collar counties, every county in Illinois has a mediation program that the court runs. 2 to 3 sessions, you know, you're sitting down with a lawyer, social worker who works for the court system, trying to hash some of this stuff out. Then a lot really just sort of depends on what comes of that. You know, once you've sat down, you with the other parent, you know, are you pretty close to, you know, getting a resolution on things like significant decision-making responsibilities, or not? And then that's really the question. If you do, that really ends the case there. A lot of cases, more than people think, really get done sort of through mediation. They come to an agreement, and then all I'm doing might be a little legal drafting or something at the end, you know, just to formalize everything into a court order. Alternatively, if you do get spit back into the court system because, you know, you've gone through mediation, you've tried to resolve this sort of outside of court, but you haven't come to an agreement, that's when it sort of gets spit back into court, and you'll have an attorney for the children appointed. You know, I fill that role, obviously not in cases where I'm representing one of the parents, but that's, you know, right? I have plenty of cases where I'm you know, what's called a guardian ad litem, or a child's representative, or an attorney for the child, where my client is a child. And, you know, it's basically, in these high conflict cases, it's a way to sort of have the kid's perspective really seen objectively by a judge. Versus sort of the he said, she said, and versus just sort of, you know, a lot of times, believe it or not, you know, a lot of parents might not be putting their kids' interests first, but might be just sort of like fighting to win rather than really doing what's in the best interest of the child. And then, I guess, right, some cases do end up with a final contested custody trial. It happens less frequently than you think about. I mean, so we're a 2-attorney law firm that does only divorce and child custody cases. We have somewhere in the neighborhood of 100 active cases at any one time. Out of those 100, and I'm just thinking that's what our number's been probably over the last couple of years, I probably end up having 3 to 5 contested custody trials a year. So I don't know if that's more or less than people think, but I think it's probably less than people think. It doesn't really happen that often when you, right, when you just think about the time, expense, frankly, the impact on the kids, stuff like that. My most recent one was that one I just mentioned. Where we at a day and a half trial, changing custody from a mom up here in Chicago to our client down in Atlanta, and a lot of it just was kids weren't going to school. So I think I'm gonna wrap up here. I think I have one question. I might even just take it offline. But yeah, shoot me any questions. And actually, I think there's a final slide here, just with my email address too. I shut it down too quick. But yeah, it's P like my first initial of my last name, P like Peter, first initial of my first name, P like Peter, POLSON at familylawchicago.com. Shoot me some email, shoot me some questions, and hope this was a little worthwhile. But yeah, really can totally be a resource for you by way of a free initial consultation. If you want to shoot me an email. Yeah, thanks again.